So what's the difference between an arbitrator, a mediator, conciliator, and how can a mediator help you even in scenarios where you might not imagine? All three of those types of facilitators can help parties come together to solve a dispute. And the dispute might be something very large, like a court case or litigation, or something small, like a negotiated contract. The arbitrator helps facilitate the communication between the parties, and it has the intention of guiding them towards a mutual agreement. It's not just a matter of having somebody in between two parties, it's for the purpose of moving towards a solution. Typically, parties that are in conflict or in dispute or arguing about something want to get to some kind of solution. They don't want to just be without any answers. Typically, the reason why parties can't come to an agreement is not necessarily because they disagree on what the solution is. In most cases, the parties already know what solution they want. Usually it's because of a misunderstanding of what the true nature of the other side has for intentions. So by clarifying the issues, understanding the concerns, the true concerns, not what's stated. Sometimes the real problems are things that are not yet said out loud. And putting priorities on the actual interests of the parties, there can be a dedicated, intentional movement towards a goal. Now, why is an arbitrator or mediator needed to do this? Can't the parties do it themselves? Well, in theory, yes. But here's what happens. In many cases, there's a personal interest in the process. There may be pride. There may be resentment. There may be prior baggage from relationship history. And those things get in the way of seeing what the other person really wants, or really what we call getting over yourself, where it blinds you to an easy solution because sometimes you may hold a grudge and don't want that easy solution. You want the other person to have to go through some pain, or maybe they want you to go through some pain to get to that answer. What an arbitrator or mediator does is breaks through all that because they don't have any particular bias towards one party or another. Now, what's the difference between an arbitrator and a mediator? Well, an arbitrator a lot of times is a retired judge or an attorney, and they typically have power of decision where they can say, here's what you need to do, and sometimes their opinion is binding. A mediator is usually a neutral third party, doesn't have to be an attorney, and they just assist in resolving the dispute. Now, they usually don't even have an opinion about what you should do. They just try to help you come to your own opinion. If they do have some suggestion, it's only that, it's a suggestion, and it's not usually binding. It's just a facilitator. A conciliator is kind of like a mediator, but usually does not meet with both parties together. They meet with the parties separately. And a mediator can do the same thing. In fact, a great mediation strategy is to have a mediator meet with each party separately, gather information, meet with the parties together, and then again meet with them separately. And here's the reason why. Many times the understandings of listening to what another person's saying is blinded, or it's distracted by paying attention to your own feelings or biases about the person. Somebody could be telling you a story, telling you what they need, but if you're so angered with the history, or if you're frustrated with the process, you may not hear all the words. In fact, many times the answer to a resolution is stated very clearly by the other side. They tell you, look, all you have to do is X, Y, and Z, and we're done. This is solved. Many times the other party doesn't even hear that direct statement because they're too focused on one of the other details. A mediator can help break through that. A good mediator will conduct those meetings with the different parties to understand the process that they've already gone through and to lay out the process of what can be done with a mediator. They can also help define and settle basic matters such as details, how long it's going to take, how many times are we going to meet. They can arrange the appointments for these meetings because sometimes parties have difficulty scheduling things when it's just the two of them, when it's not convenient. If you have a third party, they can help neutralize the scheduling part of it. The next thing they're going to do is hear out openly, without interruption, without judgment, without bias, the positions of each person. So how would it be if you are a party to any type of dispute or contract, if one person would just hear you out 100%, hear your side of the story, hear your position? Even if some of those facts aren't relevant to the case, even if you know some of those facts don't matter, somebody will listen to the whole story from you without interruption, without saying, yeah, but, without saying it doesn't matter. And they will also listen to the same thing from the other side. And that gives both sides to clear their mind for what the thoughts are of this dispute. Once all those thoughts are on the table, typically a lot of the sticking points that each person has will magically go away because they've been able to say it out loud. The remaining potential conflicts usually are not that great. Usually they're things that have either a middle ground or a compromise or a solution that meets both parties' needs and satisfies both parties. Sometimes it's over price. Sometimes it's over time frame. Sometimes it's over something as simple as an apology. Maybe the hardest thing to give. A good mediator will understand very clearly what each party needs, and it's like a puzzle. If you know how the pieces fit together, you can create a solution where the answer meets the needs of all parties. And the only way that can be done is by having a third party that does not have a bias or baggage or kind of an emotional attachment to the case. Being impartial gives that person an easy method to hear what each party genuinely needs. Not the emotional sticking points, but what the true, completely logical, rational solution is. Now, a mediator is not going to magically say, here's what you have to do. They're not going to give you the answer. Because if they did, now they're putting their third opinion into the mix. It's not going to be good. What they can do, and a good mediator has experience and knowledge in the areas of discussion, is tell you very rationally, here's what you can expect. For example, if it's a court case and that mediator has been party to court cases, they can tell you, well, if you go to court, here's what we've seen before and you might expect this. And that might take some of the conflict off the table. Many times parties expect that a court is going to do certain things. They expect that the court is going to admonish the other party or blame somebody else or take certain evidence as very highly weighted facts. In reality, a court or a judge who sees a case, their initial bias, their initial perspective on a case, by default, is going to be to look at both parties as being at fault. A judge is supposed to be impartial, and generally they are. They don't pick one side over another. But because they see all of their cases are two people that are fighting in conflict, their natural instinct is to say, well, these people are just both being ridiculous. They're both being unreasonable. So they're going to have a negative attachment to both parties. So they don't really care if either one of you gets a benefit. They just want to get you out of the court. Now, that's an overstatement, and that's a stereotype. But think of yourself as if you're a parent and every single day, or a teacher, you have kids that are fighting all the time, you're generally going to build up a jaded approach to that everybody's always fighting and everybody's always being ridiculous. Think about every fight you've seen kids have or argument. It's usually neither one of them is right. They're usually both wrong, and they both need a timeout. A judge will come to look at court cases the same way. Both people need a timeout. So the reason that it's important to be aware of that is don't expect that a court is going to magically take your side and admonish the other person or criticize the other person. Your position on your argument is certainly reasonable based on your opinion and your understanding and facts and your point of view. The other side, the other person, they have a belief about the argument or the conflict that's equally as relevant. They don't honestly think they're wrong the way you think they're wrong. So you both think you're right. You both think the other person's wrong. If you go to court, the judge isn't going to have any more belief in either person than like you do. What a mediator can do is point that out and say, look, here's what's likely to happen. If you really put it on the line, neither one of you are going to win. Most court cases, nobody wins. Even if there's a judgment in favor of one party, usually both parties end up losing by the time they spend the time and court fees. And even the judgment isn't as satisfying as what the winner thinks it's going to be. A negotiated settlement, a rationally secured collaborative agreement is always going to be better. And the mediator can help point that out. They can look at information from your documents, from your records, from even court precedents. Although they can't act as an attorney, they can tell you, look, here's another case that seems like yours. Here's what might happen. And they'll leave it up to you to come up with the resolution or the solution out of court. The meetings are private. They're typically confidential. They're less formal than a court trial. It's not, you have to put a motion and a hearing and evidence, and it's not like you have to follow specific rules. The mediator will be more informal, open-ended to let things flow how it's naturally for the parties. The mediator will have to be strong to make sure that one party doesn't mistreat the other or become dominant over the process. You want to keep it fair. And that's their role, is to make sure that it's diplomatic, it's balanced, it's managed, and everybody's position is heard. And it doesn't have to be just two people. There may be three people to a mediated case. What kind of cases can a mediator help with? Well, obviously, a court case or a divorce case can be helped with mediation, but any type of conflict, even something as small as an election for a Little League board that's disputed, a conflict between two parties to a contract, to settle what the terms of a contract are, maybe pricing on a bid proposal. It might be two people that are just trying to figure out where to go on vacation that are stuck on something. Mediators have been able to assist with very large and significant conflicts, tens of millions of dollars, all the way down to a few $100s of deciding where to hold a birthday party. It takes the emotion away from a conversation. In fact, how important is it? Well, look at an example of a real estate broker. In theory, somebody buying a house, somebody selling a house could get together themselves and sell a $400,000 or $500,000 house. But 90-something% of all home sales are done with a broker. And that broker takes a percentage that sometimes is $40,000, $50,000 of commission just to sell a house. You don't need a broker to find a house. There's Zillow, there's MLS, there's all kind of advertisements. So what do you need the broker for? Well, the broker acts as a mediator between the two parties to help keep emotion out of it. Look, somebody selling a house is giving away their life memories of the last 2, 3, 5, 10 years. Their house is their home. Somebody's coming in that's going to take over their home. The buyer of a house is falling in love with a new home. That can create a lot of emotions, and it can create arguments over value. You only think it's worth this much, you're charging too much, you don't want an inspection. There's a lot of emotions that can come up. The broker really is just a buffer between the two parties. A mediator does largely the same thing. And the only reason we bring up the realtor example is it's so important in that industry that even with the advent of technology and all kind of online platforms, brokers still exist, because without them, real estate transactions would be difficult to accomplish because the parties would engage in some escalated argument or conflict about something and no deals would ever get done. So if you could think of your life and any type of dispute, conflict, improved result that you would ever imagine, things that are happening right now, things that have happened in the past, things that might happen in the future, imagine what a third party might be able to do to help resolve that diplomatically, taking the emotion out of it and also taking the confrontation out of it. So you don't have to face the person directly without somebody on both sides. They're not on your side, they're not on the other person's side, they're representing both of you to evaluate the information you have to give, describe history and realities of what might happen, and nudging along, facilitating a good resolution for both parties without arguments or things that could be said that can create permanent damage and memories to that relationship.